So shall we begin with the session?
Yes, ma'am, we can start.
Good afternoon, everyone. I welcome you all to our today's webinar on recent important orders by Honorable NCLAT. To begin with this session, I would first like to introduce our speaker, Mr. Vikram Kumar, sir. Sir is a chartered accountant and a qualified company secretary. Sorry. So sorry. And sir is a chartered accountant and an insolvency professional. He has a vast experience of over 30 years and his qualification includes CMA Australia and CISA from USA. Sir has been appointed as resolution professional and IRP in more than 16 assignments. Sir is also a regular speaker in our full day workshop as well as other webinars on our IPA. Sir, on the behalf of ICSI IIP, I would like to welcome you and I would request all the participants to please interact in this session, and it is a humble request to keep your mics on mute. If there is any query, you may raise the hand or share the same in the chat box. So you may now please take over, and I'm so sorry for the wrong qualification.
No issues. You're only adding to my qualification.
You may
so thank you very much.
Thank you.
And I warmly welcome all the participants. So we are going to discuss about the recent orders by Honorable NCLAT, and we are going to discuss about 7 orders. So all these orders are of a very recent date. 6 out of the 7 orders are of March 2023, and 1 order is of April 2023. So all these orders are of very recent orders. What we can do after every discussion of one order, we can pause and we can have an interactive discussion with the participants. Any participants who would like to share his or her experience related to the judgment, I would really welcome to share your experience. And wherever you would like to add or share any of your experience, we welcome you to share your experience. So let's start with the first judgment. So this judgment is of 28th March 2023, and there are 2 appeals. One is the Minions Ventures Private Limited, that is the appellant, and TDT Copper is the corporate debtor, the respondent. This is the first appeal. Second appeal is Mr. VR Ashok Rao and 24 other applicants versus TDT Copper. So basically there are 2 appeals, and through a common judgment of Honorable NCLAT, they have disposed of both these applications. So the primary issue involved in this case was whether the applicant who has filed the application for admission of CIRP is a financial creditor or an operational creditor. That is the primary issue which we are going to discuss. So let's first discuss about the facts of the case. Now, before we get into the facts of the case, let me inform you that this case pertains to the invoice discounting or the receivable discounting. So the relevant provisions of the code pertaining to invoice discounting is given in section 5 subclause 8 subclause E, which I'm just reading so that we are all on the same page. So section 5 subclause 8 defines financial creditor, and subclause E says a debt along with interest, if any, which is disbursed against the consideration for a time value of money and includes receivables sold or discounted other than receivables sold on non-recourse basis. So if the receivables have been sold on non-recourse basis, then it will not be considered as a financial creditor. So the primary condition is that the invoice discounting should have happened on a recourse basis. Now, before we discuss the facts, it is important to discuss there are 2 ways of invoice discounting. First is the the ordinary invoice discounting, and second is the reverse invoice discounting. So I am sure you all are very conversant with what is invoice discounting, but still for the benefit of the larger participants, I would just spend 2 minutes and explain you what is invoice discounting and how is reverse invoice discounting different from invoice discounting. So in invoice discounting, what actually happens, the seller gets his invoice discounted through a factor, and then the factor directly pays to the seller, and ultimately the corporate debtor or the buyer has to pay to the financer. So let me go to the next slide, and I will, through the diagram, I would be able to explain you what is invoice discounting. So if you see in the diagram, you have a seller, you have a buyer. The first transaction is of the sale of goods by the seller to the buyer. Now in the second transaction, what happens? The seller gets his invoice discounted. He submits the invoice to one of the factors. In this case, it is Hero FinCorp. Now Hero FinCorp will directly make the payment of the invoice to the seller. So he will discount the invoice, and a certain fraction of the discount, he will deduct. Say 100 rupees is the invoice, 75 rupees, for example, he will pay to the seller. Now on the due date, the buyer will make the payment of 100 rupees to the financer. Now with in case of recourse, I would request all the participants to kindly mute. Now, since it is a recourse basis of financing, so if suppose the buyer fails to pay, then the creditor will have a recourse to the buyer, to the seller. I hope this is clear to everyone. What is the basic, feature of invoice discounting? And in reverse invoice discounting, it is slightly different. Instead of the seller, can you mute this Malav Jitendra? Ma'am, can you mute everyone, please? Yeah. So in the case of reverse invoice discounting, instead of the seller, getting his invoice discounted, the buyer initiates the process of discounting. So if you see in this transaction, the first transaction is same. The seller is selling the goods to the buyer. Now the second transaction is the buyer is actually initiating the process of invoice discounting. The buyer approves the invoice and informs the platform. So this is the platform where, the invoices are discounted. So the invoice is actually given by the buyer to the platform for discounting, and the seller is also seeking payment directly from the platform. So there is no direct link between the buyer and seller here. In the platform, they are both, basically putting in their invoice, and the financer is in turn directly making payment to the seller. And on the due date, the buyer will make the payment to the financer. So the transaction is very similar, except in case of invoice discounting, the seller is initiating the process. In case of reverse invoice discounting, the buyer is initiating the process. That is the basic difference between these two processes. So now, with this background of invoice discounting, we would discuss the facts of the case. And once we discuss the facts of the case, then, we would be able to appreciate that, what exactly has been held by the Honorable Court. So this is an appeal filed against an order dated 11th March 2022. That is the date of the order passed by the Honorable NCLT, against which the appeals have been filed. So there were 25 applicants claiming to be financial creditors. They have filed an application under Section 7 before the adjudicating authority, and adjudicating authority has dismissed the application under Section 7 with a liberty to them that you can file an application under Section 9. So they are claiming to be financial creditors. However, the NCLT says you are not a financial creditor, so you cannot file an application under Section 7. You can, however, file an application under Section 9. So that's the reason why the applicants have filed an appeal before the NCLAT challenging the order of the NCLT. Now, in this case, TDD Copper is the buyer and the corporate debtor against whom the process was, CIRP was initiated. TDD Copper purchased certain copper products from the buyer. Now the seller is Ashoka Creations Private Limited and buyer is TDD Copper. The total value of the invoice is 3.42 crores. Now, Minion Ventures is actually running a very popular platform called Credex. Credex is an online platform which is actually into the invoice discounting and reverse invoice discounting, which is basically called as a supply chain financing. So these are typically for the working capital financing. Now this Credex has been actually funded by all the marquee private equity funds like Sequoia and all these big private equity funds, and it's a very popular site for supply chain financing. And the promoter of Credex is Minion Ventures. So if you recall the citation of the judgment, I'll just go back to the citation. The Minion Venture is the first applicant, and in the second appeal, the financial creditors, that is VR Ashok Rao and others, are the appellants. So let us say that VR Ashok and 25 others are the financial creditors. Buyer is TTT Copper. Seller is Ashok. The seller, just I'll repeat the name. The name of the seller is Ashok Creations. Right? Now, the seller and the buyer both are registered on Credex. And the financiers, that is 25 people, are also registered on the online portal, that is Credex. So what happens after the sale transaction, the buyer uploads the invoices of the seller on the platform, that is Credex. And the financiers are basically financing the invoice uploaded by the buyer on the platform. So here, all the financial creditors claiming to be financial creditors are the appellants. So they discount the invoice of 3.42 crores and they actually pay 1.75 crores into the bank account of Credex, which is maintained with Just Bank. And that amount is then remitted by Credex to the seller, which is Ashok Creations. So the money goes directly from the financial creditor to the seller. And as a result, the liability of the corporate debtor, that is TTT Copper, extinguishes with respect to the seller, and similar liability is now of the corporate debtor to the financiers, that is VR Ashok and 25 other applicants. Now the default happens on part of the corporate debtor, TTT Copper, in making the payment to the financiers, that is VR Ashok and 25 other applicants, on the due date, as a result of which these financiers make a joint application to NCLT for admission of an application under Section 7. So I hope these facts are clear, and prima facie, you would believe they are financial creditors because they have actually, financed the transaction, and this transaction prima facie appears to be completely squared, covered under Section 5, subclause 8, subclause E. So let us further, continue with the facts of the case. Whenever these transactions happen, there are certain agreements to be signed. So there is an agreement which is called as creation of rights, wherein the agreement is between the seller, financier, and the buyer. Now, what is the agreement here? Now, as per the agreement, the seller has to receive the payment. So the seller has agreed for discounting of the invoice of the customer, because without his agreement, the invoice cannot be discounted. So seller has agreed for discounting of the invoice of the customer, for creation of the right and interest in the invoice in favor of the financier. That is the basic agreement through which the rights of the seller is shifting from the seller to the financier. Now, as per 5.2 clause of the said COR agreement, the seller transferred its right to receive the amount from the buyer directly to the financier. And lastly, clause 4C says of the said agreement that the seller has agreed for discounting of the invoice. So that is a nutshell. I'm just, giving the basic points of the agreement. So these are the basic facts of the agreement, that the seller is ready to assign the rights to the financer, and is also ready to get his invoice discounted and get the payment from the financer. So I'll just pause here, and I would basically, ask the participants, what is your prima facie view? Do you believe it is a financial creditor, the appellants are financial creditors, or you believe that they are operational creditor?
They are operational creditors because this is a case of assignment of dues. The
Assignment of?
seller is assigning his receivable right to the financiers. So whenever you do the assignment, the nature of debt will remain same.
Okay.
Because for seller, the nature of debt was as a operational debt.
Correct.
So the same thing should continue to my mind.
Okay, fair enough. So we'll continue and just see the reasons for the dismissal of Section 7 application by the NCLT. I'm given two highlights here. There is no disbursal of the amount to the CD by the financiers. So the money has directly gone from the financiers to the seller. Seller is an operational creditor here. And number two, Section 21 subclause 5 is very, very relevant here. So let me read Section 21 subclause 5, which says, where an operational creditor has assigned or legally transferred any operational debt to a financial creditor, the assignee or the transferee shall be considered as an operational creditor to the extent of such assignment or legal transfer. So as Mr. Pawan Vashni had, very rightly said, that who is transferring, his rights? The seller is assigning the rights to the financier, and seller here is an operational creditor. So technically what is happening is the debtor is only, paying the financier against the debts assigned by the seller. Let us further continue. So what are the issues before the Honorable NCLAT? Let us see what are the issues involved. The first issue is whether the appellants, that is V.R. Ashok Rao and others, 24 others, are financial creditors as against the corporate debtor TDT Copper, or they have stepped into the shoes of the seller as an operational creditor. That is the first point. Second is whether Section 5 subclause 8 subclause E is applicable or not applicable. We have already seen what is Section 5 8 subclause E. Now the third point is important, whether the financiers had reverse discounted invoices on recourse basis to the benefit of the corporate debtor, and thus they are the financial creditors vis-a-vis the corporate debtor. So what the appellants or the financial creditors are saying, that they have basically discounted the invoice on behalf of the corporate debtor. So they are actually paying on behalf of the corporate debtor for the benefit of the corporate debtor. So they are financial creditors. Now the next point which is applicable, which was before the Honorable NCLAT, was that whether Section 2551A is applicable in the matter or not. So what is the decision of, now there are certain decisions, judgments of the court, which has been relied by TDT Copper, which is also important to discuss here. So first judgment is of Supreme Court judgment in JP Infratech versus Resolution Professional. Now, what happened here, the Honorable Supreme Court held that a debt to be financial creditor, disbursal against consideration for time value of money is a prerequisite for declaring the transaction as a financial debt, and the money should come into the account of the corporate debtor. And the second judgment has been referred by the TDT Copper was the case of Cooperative Rabo WA Singapore branch versus Shailendra Ajmera. In similar matter was there, wherein Honorable NCLAT held that the applicant was a operational creditor. Now, what is the decision of the Honorable NCLAT? The Honorable NCLAT held that the transaction, basically the money was never disbursed as a financial debt to the corporate debtor. And by virtue of the invoicing of, by virtue of discounting the invoice of the seller of an amount of 3.42 crores, 1.75 crores was paid by the financiers to the seller, and he stepped into the shoes of the seller who was an operational creditor. So section 21 subclause 5 will be applicable, and section 5(8) subclause E is not applicable at all. That is the first point. Second is, at no point of time the amount in question was disbursed to the corporate debtor, as was held by Honorable Supreme Court in the JP Infra case. Third point is, financiers took the invoice of the sellers and discounted the same, and they stepped into the shoes of the operational creditor as operational debt. And lastly, the goods have been supplied by the seller, and the sellers have assigned the right and the interest under the invoice to the financiers. So the Honorable NCLAT upheld the judgment of NCLT and said that the applicant is not a financial creditor, but an operational creditor. So in conclusion, what I'm trying to basically, further simplify the whole order as, instead of the CD making the payment to the operational creditor against the goods supplied by it, because the transaction basically of purchase and sale is an operational transaction, and the CD is not making the payment. Had the CD made the payment, it would have been the operational debt. Instead of CD making the payment, a payment has been made by a third party who is a financer, and the CD is liable to make the payment to the third party. Hence, this is an assignment of operational debt to a financial creditor as per section 621 subclause 5. Since no amount has been paid by the CD for time value of money, the financiers are operational creditors. Second is also very important to note, in section 5 subclause 8E, basically it talks about the receivables are sold or discounted. Now, what is important is the receivables sold and discounted should have been of the CD, which is under CIRP. So you will notice here the receivables are of the seller and not of the CD. Had those receivables been of the CD, then they probably would have been financial creditors. So this is the first judgment. I'll just pause here, and in case any participant would like to share any of his experience, I would be very happy to hear their experience in the similar matters.
Sir, may I, sir?
Yeah, please, sir. Please,
Sir, I think we should also look into the definition of operational debt.
Okay.
Which says section 5 subsection 29, which says operational debt means a claim in respect of the provision of goods or services.
Correct.
This is the bill discounted was only in relation to provision of goods or services.
No, that is fine. Avnish, that what point you are raising, that's fine. The transaction is an operational transaction. That is very visible. The complexity which comes in is because you see a financer coming into the picture. Now,
but the claim.
What you're saying is right.
Yes.
What you are saying is right. So actually, this judgment has a great ramification on the business of factoring, because suppose instead of TDD Copper had Ashok Creations went into a CIRP. Ashok Creation is the seller.
Seller.
If you go to my first slide.
Okay.
So if you see here, Ashok Creations is the seller. Now, what happened if suppose Ashok Creation would have gone into insolvency? and he would have got the invoice discounted through the Credex platform. Are you getting my point, Avnish?
Yes, sir. Yes, sir.
That would change the whole scenario. Do you agree with me?
Yes, sir.
So that is the limited point I'm trying to make, that even though the transaction would be of sale and purchase, but if those invoices are discounted by the seller, and if seller goes into CIRP, then it becomes a financial debt. So who is going into CIRP is also important here. Anyone else would like to, share his experience? Or we can go to the next judgment. Okay, so let's go to the next judgment. The next judgment is also, of a very recent date, 31st March 2023. Now, in this judgment, Prime Impex is the operational creditor who has actually initiated the process of CIRP, and Shelfio Industries is the corporate debtor. Deepak Modi happens to be a suspended director of the corporate debtor. So these are the persons involved. Prime Impex is the applicant who has filed a Section 9 application. Shelfio Industries is the corporate debtor. Deepak Modi is the suspended director of the corporate debtor. Now, what is the issue involved here? The issue involved is that when the operational creditor initiated the process, the CD said that the amount is not payable because there is a dispute. Now, the issue before the court was whether the dispute is a genuine dispute or it is a frivolous dispute. Because in any Section 9 application, as you are all aware, the crucial point is that if there is a dispute, then the application cannot be admitted, provided it is a genuine dispute. So let us see what is the facts of the case. So a Section 9 application is filed by Prime Impex against Shelfio Industries, which is a CD. And Deepak Modi, as I told you, is the suspended director of the CD. Now, Prime Impex is engaged into the business of marble and granites in the state of Rajasthan. They have their manufacturing facilities in the state of Rajasthan. The amount of debt default involved is 11.95 lakhs only. Now, the corporate debtor, that is the Shelfio Industries, is basically a civil contractor, and it's engaged into the contracting with airport. So they are actually into laying the granites flooring at various airports. Now, against the sale made by Prime Impex, PDCs were issued by Shelfio Industries, that is the corporate debtor, and those PDCs got dishonored. Now, SGB Infra Limited is the principal contractor, which has allotted the work to Shelfio Industries, the corporate debtor in this case. And after the goods were supplied, there was some kind of a dispute between the parties, and the payment was not made by the corporate debtor to the operational creditor. So SGB Infra principal contractor allotted the work to the corporate debtor, and the corporate debtor was required to complete the flooring at Jaipur International Airport with specified quality. Now, what is the dispute involved here? The dispute is that the granite slab should be at least of 16 mm to 18 mm, whereas the goods supplied here by the OC was 15 mm to 15.5 mm. So there is a difference in the thickness of the material supplied by the operational creditor. That is the main point of dispute in this case. Now let us see what is the details of dispute. So the applicant has supplied the supplier has supplied 6 invoices in total amounting to 14.748 lakhs. And the dates are important here. The goods have been supplied from 21st September 19 to 5th December 2019. Now an inspection happens by SBL Infra, which is the principal contractor, on 15th December 2019. Please note, the goods were supplied last date of supply was 5th December 2019. And on 15th December, so about after 10 days, the inspection happens of the goods supplied. Now, what is the SGB Infra saying? They are saying that the letter wide 16th December 2019, they say to the CD, you are requested to remove the flooring on account of deficiency in quality of the goods supplied. So this implies that the granites were already fixed on the floor and they had to be removed, because if you see the language, it says remove the flooring on account of deficiency in the quality of goods supplied. So the OC has alleged that at the time of unloading of the goods of premises, the CD did not raise any dispute or any complaint with respect to the quality of goods. And one very serious allegation has been imposed by the operational creditor against the corporate debtor. They said that the delivery slips given by the OC or the seller has been forged by the buyer. That is, this company, Shelfview Industries. So Prime Impact says when the goods were supplied, the Shelfview Industries did not raise any dispute, any complaint. They had accepted the goods. And on the delivery slip, they have forged the delivery slips. I will show you what forging has been claimed by the OC. So OC, on account of the forging, has actually initiated an application under Section 340 of the Criminal Procedure Act against Shelfview Industries. Now let us see what is the allegation of the OC against the CD for the forgery conducted by the corporate debtor. So I don't know whether you can read, what is highlighted in red triangle, but what I would just read it out for you. So OC has alleged. So if you see here, it basically says that if you carefully see, it is saying mal 14.5 to 15 mm hai. And then it says that purana mal naya mal diya jayega. Something of that sort is written here. So what is stated here, OC has alleged that CD has forged the documents and wrote on the delivery slip that goods are of 14.5 mm to 15 mm and the entire goods will be replaced. This is what is written in this triangle box. Now I'll take you to the next slide, which is the original delivery slip given by the OC before the Honorable NCLT. So if you see, this is the original slip. You will not find here any comment written on the delivery slip as compared to this. That goods are of 14.5 mm to 15 mm and the goods will be replaced. However, OC says it was never written by the OC at the time of delivery. The slip is blank here. That is the main point of contention in this matter. Now let us see further the facts of the case. So OC has alleged that the goods were supplied by the OC and has been already consumed by the CD. As you know, we had seen earlier that the goods have already been placed at Delhi Jaipur International Airport, and said goods was asked by the principal contractor to the CD to remove the flooring because they were not of specified quality. Now what the NCLT held, NCLT said that inspection should have been held at the time of delivery of the goods by the OC. Since the goods have been consumed by the CD, it is obligatory on part of the CD to pay the operational creditor. So goods have been already consumed by the CD. So it is obligation on part of the CD to make payment to the OC. OC has alleged the CD has not properly executed the contract. So what basically the OC is saying, the laying of the stones on the floor has not been properly done by the CD, as a result of which SGB Infra, the principal contractor, asked the corporate debtor to remove the floor. So the core issue before the NCLT was that is there a plausible dispute in respect to quality, or there is no pre-existing dispute? That is the primary issue. Now, what is the decision of the Honorable NCLT? The Honorable NCLT says, in the present case, it is reflected from the inspection report of SG Infra that the corporate debtor was asked by the SB Infra to remove the flooring. This fact is in itself enough to draw the inference that CD had accepted the delivery of granite slabs made by the OC without raising any dispute or objection. Otherwise, the CD would have rejected the material at the time of unloading. So that is the first point. Second is, it is clear that granite slabs supplied by the OC have been consumed or utilized by the CD and had placed the same at the premises of the Jaipur airport. Third point says, there may be plausible reasons for SGB Infra to ask CD to remove the flooring, but the fact remains that the CD had accepted the granite slab supplied by the OC without raising any dispute or objection. On this score itself, we are of the opinion that such plea of the corporate debtor regarding dispute can be termed as moonshine defense. Now, the next point is that OC has already filed an application under section 340 of the CRPC in respect of the forgery committed by the CD. Hence, the appeal of the appellant was dismissed and the decision of NCLT was upheld that it is a genuine, there is no dispute and the payment has to be made by the CD to the OC. So this is the second judgment we have discussed. And in case anybody would like to share his or her experience related to some kind of dispute in an section 9 application, you are most welcome. One last point I will make here. If you notice here, the amount of default is a very small amount of 11.95 lakhs. Now, as you are all aware that the default amount has been increased to 1 crore with effect from 24th March 2020. However, in the order, it doesn't speak about this default of 1 crore. So I presume that this application was filed prior to 24th March 2020. Otherwise, this application could have been dismissed without any discussion. That is the limited point I want to make. Now I'm happy to have the views of the participants. If anybody would like to share his or her experience. Anybody, please?
Sir, I have one point to discuss on this.
Yeah, please, Mr. Jashwant.
Yeah, the situation is like this. I sold some material to Mr. X.
Okay.
And after that, I supposed to receive the proceeds.
Okay.
As consideration. We have several other transactions in between both the parties. And instead of returning that my money to me, I asked the person to give it to Mr. Y as a security of the contract which me and the other party was doing.
So the OC says you supply the goods I have supplied to the CD to somebody else, a third party, as a security.
Yes, the proceeds.
Okay. Proceeds.
The proceeds, yes.
Oh, okay.
So the transaction now, the CD is under the liquidation or the CIRP.
Okay.
So my status is as of OC or FC in this matter?
The OC only, na? Why FC?
Sir, what the we assume that he's supposed to give us the money back.
Okay.
And instead of just routing the transaction, we ask him to keep the money and use for the other purposes. We execute one agreement with him.
What is that purpose? Is he a kind of a loan given by the OC to the third party?
Basically, this is kind of bank advance for the bank guarantee given for a joint project.
So my simple point submission here is, Mr. Jashwant, that you will have to see what is the transaction between the OC and the third party. If suppose OC is lending money to the third party and against the time value of money, then it will be a financial debt.
Financial debt, right, sir.
Yeah.
Also think the same. Thank you, sir. Thank you for your views.
Yeah.
I am Partho Sen. I also have an observation here. You know,
Yeah,
what's
please,
happened, NCLAT said there is a moonshine dispute. But if you see
Yeah.
the order passed by NCLAT in Nike India Private Limited case, where they have said moonshine dispute is, I mean, it is a whimsical, allegation. But
Okay.
but here the allegation is correct. That supply of goods is absolutely not as per the quality mentioned in the order.
Agreed.
But I feel here it is a case of recovery of the debt. So recovery is not covered under IBC. IBC,
How do
NCLT
you-
has no power to judge the recovery aspects of the case.
No, the point is that you are going into a very fundamental issue, but the point is that there is a default, no doubt about it.
Yes.
The OC has not been paid 11.95 lakh rupees,
Yeah.
and I'm presuming this case pertains to 24th March 2020,
Right.
when the default was 1 lakh rupees.
Right.
So there is a default.
Right.
Now, naturally, if the CD has defaulted, the OC will initiate a process of, a resolution process only, because if suppose the CD is not in a position to pay, it means the CD is financially not sound to, carry on the business.
But basically, when the CD also challenges that they have accepted my material, and
Right.
at that time they did not raise any question. So
Right.
it is tantamount to a recovery case.
No,
NCLT can judge in that way also, that since they have already said, and it is evident that you have not raised any question. So instead of writing that this is a moonshine means totally whimsical, allegation.
Right.
But there the allegation is that whimsical.
Moonshine is frivolous, actually. It's a frivolous
Absolutely,
kind of a
absolutely.
dispute.
Nonsense.
Correct.
Moonshine means nonsense.
Correct.
So it is not a nonsense allegation.
So,
Allegation is correct.
point is that the goods were actually not of the specified quality. But the
Right.
point is, if you consume the quality goods and then you raise a dispute, that is not a genuine dispute. Na? That is the point actually being
Now, sir,
discussed here.
I want to make the difference with genuine, not genuine mistake and nonsense dispute.
Anyway,
What I mean to say that it is not a nonsense dispute.
that is, a person to person can decide. Ultimately,
Yeah.
these are for the courts
But
to decide.
I feel it is totally a recovery, aspect, and that NCLT cannot judge.
So strictly speaking, Mr. Partha Sen,
Yeah.
everything is recovery under IBC. Even though, the law is not meant for recovery, but the OCs are only interested in recovery. OCs are not interested in resolution. All the OC applications are technically for recovery only, because they are not competent enough to go in for a resolution.
But sir, you have to see the weightage. How much?
So that is the courts. I cannot get into this point, because the courts will decide whether it is a recovery or it is a resolution.
Right.
That is something for the courts to decide.
That's my observation.
No, I agree.
You are
But this is
absolutely
the
right.
point where we cannot say anything actually.
Yeah, I agree.
Any other point anybody would like to say? Or we can proceed to the next judgment. So let us proceed. So this is a very latest judgment of 24th April 2023. And let me explain you what happened here. Here, Praveen Gupta, and there are 6 more parties, so total 7 applicants. And Pooja Bhari happens to be the resolution professional of NTL Electronics. So certain transactions, were claimed to be fraudulent and preferential in nature. And the RP filed an application for basically recovery of the preferential transaction. The Honorable NCLT upheld the application of the RP, and these applicants have then challenged the decision of the RP before the NCLT. So let us see the facts of the case. This is a very, very important judgment, because some very important points have been raised here. So the judgment against which the appellants have gone to NCLT is IA 5768, dated 2nd March 2022, wherein some preferential transactions were claimed by the RP. The CRP date is 27th August 2019. Now let me explain you very briefly what is the nature of the transaction which has been claimed to be preferential in nature. So all these applicants, some are related parties to the CD, some are not related parties to the CD. They have extended loan to the corporate debtor. So this is a very normal transaction. In most of the cases, you will see directors and non-related parties have given loan to the CD. Now the loan was taken by the CD for running the business as a going concern, and the amount was utilized by the CD for running the business as a going concern. This point I am going to stress that loan was taken to run the CD as a going concern, and it was also utilized by the CD for running the business. Now the repayment of the said loan happened during the look back period. So as you are aware, the look back period under section 43 is 2 years for related parties and 1 year for non-related parties. So 2 years prior to the CIRP date for related parties and 1 year prior to the CIRP date for non-related parties. So all these repayment happened within the look back period. Now the application for proof of transaction was filed prior to the filing of application for approval of the resolution plan. This is the crux of the whole transaction. So loan has been given to the CD by relatives and non-relatives. These are mostly individuals. And they have given loan to the CD because the CD needed money. CD was, into a financial strain. And those money has been used for running the business as a going concern by the CD. And the RP says that the payment made to these applicants during the look back period is preferential in nature. So let me pause here and let me, ask the participants, how many of you believe that this transaction looks like a transaction of preferential nature?
Yes, I think so. I mean, it is preferential nature because they are giving preference to other creditors by paying them. I mean, okay, the terms of the agreement maybe that it falls under the look back period, but there is a preference is given by paying them the money.
So, Mr. Sen, let me ask you.
Yeah.
The amount has been given for running of the CD as a going concern, and it has been utilized also.
Yeah.
For running the CD as a going concern.
Right.
There is no misutilization of the money.
Right.
Does it make a difference?
Not really, because ultimately the CD has gone to CIRP.
Okay, so let's hold your thought. Let me have other views as well, and then we will proceed. Anybody else would like to?
If this is the case, then I don't think so. These are professional transactions.
So it is not a professional transaction.
Yes, sir.
Why do you think so?
So these are the normal day-to-day transactions.
Ordinary business.
Yes.
Transaction in the ordinary course of business.
Yes, and CDS might have paid so many other people in the past 1 year or 2 years,
Correct.
depending whether they are related or not.
Anybody else?
So for preferential transactions with related party, there is a clear line in section 40p that transaction with related party would be presumed to be preferential, whether it is for ordinary course of business or other than ordinary course. So with that perspective in mind, at least the transaction with the related parties are definitely preferential.
Okay. So, Mr. Varshne, just hold your thoughts, but let me tell you that your views are not correct. Okay. Once we can conclude on this judgment, you would change your views. So just hold your thoughts here.
Okay.
Yeah, Mr. TVS Shiva Prasad. Mr. TVS Shiva Prasad, you have raised your hand.
I have a view here, sir.
Yeah, Mr. Soni.
I am Neeraj Agarwal.
Yeah, please.
To be a preferential transaction, any payment if made has to be made, to a creditor, existing creditor. Okay. Number one, having a credit balance in the books of the CD. Number one. Number two, there are other parameters which need to be checked.
Okay.
Is
Okay.
the CD is into NBFC business and lending business? If it is not into lending business and it has given the money to only some sister concerns out of the term, then it is definitely a preferential transaction.
Okay. So thank you, Nilesh. I'm just taking the views of the audience because we will proceed and then probably you will change your views. So let us continue, or if somebody would like to further express their views here. I think let us continue.
Took the
So-
order of
Yeah, Mr.
Ongoing
Soni. Yeah, somebody was saying something. Anyways, so let us see what are the ingredients of section 43 would constitute, or what transaction would constitute a preferential transaction. So what are the ingredients, or what are the relevant questions to be asked and answered to consider a transaction to be preferential? The first is there has to be a transfer of property. Now, property has a very wide connotation under IBC. The property is defined under section 3 subclause 27. So that you can read, but property has a very wide definition. Now, the transfer of that property is for the benefit of a creditor or a surety or a guarantor. So that is the first question. That transfer should happen, transfer of benefit of property should be for the benefit of a creditor or a surety or a guarantor. Now, the transfer should have on account of antecedent financial debt or operational debt. So there has to be an existing financial debt or an operational debt, and on account of the existing debt, the transfer should have happened. Now, lastly, the effect of that transfer, this is a very important point. The effect of that transfer should actually put that creditor or the surety in a beneficial position as compared to the distribution of assets under section 53 of the IBC code. These are the relevant parameters to be checked to consider a transaction to be preferential in nature. Now, there is a provision which says that even if the transfer happens, but the transfers will not be considered a preferential transaction if the transfer is made in the ordinary course of business or financial affairs of the corporate debtor. Now, here I would like to make a very important point. If you read the provisions of the code, section 43, I have highlighted the word "and" in bold letters here. If you see the language in the code, it is actually "or." So the language is transfer made in the ordinary course of the business or financial affairs of the CD or the transferee. However, the Honorable Supreme Court, in the matter of Anuj Jain versus JIL, that is the Jayaprakash Infra, Supreme Court said that the "or" should be interpreted as "and." That is why I have written here "and" here, and has a special significance here that we will discuss. The expression ordinary course of business or financial affairs. Now, please understand here, the transaction which has happened is of loan given by related and non-related parties to the CD. So prima facie it appears that this transaction is of the nature of financial affairs. That was one of the arguments taken by the appellants, that financial affairs of the CD would cover loans taken by related and non-related parties of the CD. But the Honorable NCLAT, I think some people have kept their mic on. I would request everyone to kindly mute. Yeah. So the Honorable NCLAT says that ordinary course of business or financial affairs should be read as adjustem generis, which basically means of the same kind. So you can't have a meaning of the term ordinary course of business completely separate from financial affairs. So the meaning must be adjustem generis, that is of the same kind. And the expression financial affairs of the CD cannot be given an extended meaning so as to include all financial transactions done by the CD. I hope I have been able to make this point clear to all the participants that what are the primary ingredients of section 43. So let me very quickly repeat. There has to be an antecedent financial debt. The transfer is for the benefit of a creditor who has an antecedent financial debt or an operational debt. And on account of that payment to the creditor within the look back period, the creditor is in a beneficial position as compared to if the payment was made under section 53. And the payment should not have been made in the ordinary course of the business. These are the main points to be checked here. So now let us discuss one by one. And what is ordinary course of business? Something very, very important to understand. And the judgment has very elaborately, explained what is ordinary course of business. So let us see what is the observations and the issues before the Honorable NCLAT. The first issue is the RP had no authority to pursue the avoidance application in view of the position of law as declared by Honorable Delhi High Court in the matter of Venus recruiters. I'm sure all are aware of what is the judgment of Venus recruiters, wherein the Delhi High Court had held that avoidance application post approval of the resolution plan becomes infructuous. However, the Honorable NCLAT held that the said judgment of Honorable Delhi High Court was overruled by the division bench of the Honorable Delhi High Court. So hence that judgment does not hold ground anymore. Kindly mute everyone, please. The second point is resolution plan does not authorize the resolution professional to pursue the application. These are the arguments made by the appellant before the NCLAT. Payments to the appellants are less than the amount deposited by the appellants to the CD. So the appellants had given a loan of 28 crores to the CD, and CD has returned less than 28 crores.
Yearly,
Mr. Naresh Malhotra, please kindly mute. So what they're trying to say that the appellants had given 28 crores to the CD. However, the return of money by the CD to the appellant has been less than 28 crores. Now, payments made in favor of the related and non-related parties had the effect of putting the appellants in a more beneficial position as compared to distribution under section 53. Because had the money been distributed under section 53, they would have been unsecured financial creditors. So they would have got nothing in the process. Now the next point is very important. Giving of loans to the CD was part of the ordinary business of the CD, and hence it is not a preferential transaction claimed by the appellants. Now this is a factor which has to be considered, whether giving loans to the CD by related and non-related party is a business in the ordinary course of business or not. I hope there are no queries at this point of time. We can proceed. Now, what is ordinary course of business? Let us discuss this point. This is very crucial in under section 43. What is ordinary course of business? The Honorable NCLAT says ordinary. Mr. Satish Patodia, kindly mute, please. So the ordinary course of business basically means payments of routine nature. Mr. Patodia, kindly mute. Okay, so payments of routine nature, like payment for electricity, telephone, even payment to trade supplies are all payments of common ordinary course of business. The second point is what the Honorable Supreme Court had held in the matter of Anuj Jain versus JP Infra, where Supreme Court said transaction falls in the place as a part of the undistinguished common flow of business done. This is the language used by Honorable Supreme Court. undistinguished common flow of business done. That is, basically a part of the ordinary course of business. Now, this is the most important point here. Corporate debtor NTL Electronics was engaged in the business of manufacturing electronics and electronic components, and they had sought financial assistance from some banks and financial institutions. Taking financial assistance from related and non-related parties cannot be held to be ordinary course of business of the corporate debtor. This is the main point of contention in the whole judgment, whether taking loans from related parties and non-related parties can be considered as a transaction in the ordinary course of business. Now, the next point is, in the IBC, preferential transaction and fraudulent transactions has been separately defined, and the ingredients to prove are different for them. There is no need to prove any fraudulent intent for a preferential transaction. This is under highlight. This is very, very important to note that the intent of a fraudulent transaction is not applicable for a preferential transaction. Whether a transaction is preferential or not a preferential, fraudulent angle is not to be examined. So somebody said that, the transaction with related parties will definitely constitute a preferential transaction is not a correct understanding. Now, on the plea of the appellant, now what is the plea taken by appellant? Transaction was undertaken due to pressure on behalf of the lenders, and therefore the loan transaction was not a voluntary transaction. They are taking a plea that it was not a voluntary transaction because the money was given to the CD by the related parties and non-related parties under pressure, because otherwise they would have filed an application under Section 138 of the Negotiable Instruments Act. So what the Honorable Court says, that whether the act is voluntary or not voluntary is of no relevance in deciding a transaction is preferential or not. Now, the next point is also very important. If you read the proviso to Section 43, subclause 3, I have written here within inverted commas, provided that any transfer made in pursuance of the order of a court shall not preclude, that is prohibit, such transfer to be deemed as giving a preference by the appropriate debtor, corporate debtor. So please understand, even the transfer made on the orders of the court would also be considered as a preferential transaction. So what the Honorable NCLT says, transactions under any notice, demand or threat shall not lose its character of preferential transaction merely on the above reason. So further to continue, the appellants argued that another point has been raised by the applicant. This is again flowing from the Anuj Jain versus JP Infra case. If you remember the Anuj Jain's case of Supreme Court, wherein what the Honorable Supreme Court had held, that separate application should be filed for 43, 45, 66. You should not file a composite application for all the various proof transactions. But here, the RP had filed a composite application under 43, 45, 66. Every transaction was being filed through a composite application. So what the appellant said to the court, that the RP had filed a composite application and it was not maintainable as per the order of the Honorable Supreme Court. So what the Honorable NCLT held, that the RP had dealt with preferential transaction undertaken by the CD and undervalued transaction undertaken by the CD, as well as fraudulent transactions in different heads. Thus, allegations of averments were separately made, and filing of composite application does not lead to any infirmity in the application. So you can also file an composite application provided you have separate sections for separate reliefs and separate pleadings for the separate proof transactions. Hence, the Honorable NCLT upheld the decision of NCLT and dismissed the application filed by the appellants. So the loan entries were considered as preferential in nature, and the appellants were directed to refund the amount to the account of the corporate debtor. So let us pause here and let us discuss, because it's very common to see in most of the CIRP cases, loan has been given to the CD, and if the business of if the CD is not in the business of taking loans and giving loans, then taking loans from parties other than banks and institutions will not be considered as a loan taken in the ordinary course of business. Anybody would like to share his or her experience here?
Sir, respectfully,
Yeah, Mr. Rajiv.
yeah, could you please repeat the point? Why and how RP post even was permitted to carry on this case
Okay.
as against the earlier Venus thing?
Okay. So in the Venus judgment, if you remember, the Honorable Delhi High Court in the Venus judgment had held that the avoidance application would become infructuous after the plans have been approved, because there is nothing called as an XRP under the code. However, the decision of Venus recruiters have been actually basically reversed by a division bench of the same court. So that judgment is no more valid or relevant. That is one point. So your point is that if the Venus judgment was relevant, then naturally after the approval of plan, you cannot discuss about a proof transaction. But that judgment has been already reversed. That is your point, Rajiv?
Yeah, I just wanted to cross check that obviously in case that has been relied upon, then it has not been taken to the level of Supreme Court, or it is not under the consideration of Supreme Court.
I think that judgment is still pending before Supreme Court. I'm not sure, but this is, I think, this is pending before Supreme Court. But what is important is that division bench of Delhi High Court has already reversed that judgment.
As on date, definitely it holds good.
Correct.
That
so that is the reason why. That is the reason why the NCLAT said that you cannot rely on the judgment of Venus recruiters.
Sir. Point well taken. Thank you.
Yeah. Any other points? Somebody would like to share experience.
Sir, one point which was coming to my mind, even I faced the same thing in my process also. Yeah. Many times it happens like the banker is having non-funded facilities like bank guarantee and LCs.
Right.
And many times the margin money is kept with the respective bank.
Okay.
So even after the start of the CIRP, we are demanding this, the margin money to come into the process. But usually the bank is reluctant to give that money, and they say that they will be adjusting that money against their outstanding. So, sir, this amount, whether it will come under the definition of a preferential transaction?
No, that is completely different. Please understand, the banks have given the money. The business of the bank is to lend money. Here, the case is completely different, Abhijit. So what has happened is that the company is into the business of manufacturing electronic components. Now, they have taken loan from banks and institutions. That is fine. But they have also taken the loan from related and non-related parties. So what the judgment says, that the company NTL Electronics is not in the business of taking and giving loans, number one. So the transaction of giving loan to NTL would not come within the parameter of an ordinary course of business. And since the money was repaid to them within the look back period, so it would tantamount to a preferential transaction. Because in preferential transaction, it is not important that it is a related party or a non-related party or a fraudulent transaction or undervalued transaction. These are not relevant here. All you have to see that there is an antecedent financial debt, number one. That is an existing debt is there, whether it is an operational debt or a financial debt. Now, the antecedent financial debt is being paid during the look back period, and the payment being made is in such a way that the creditor is into a beneficial position as compared to the distribution under section 53. And the payment should have happened not in the ordinary course of business. These are the 4 broad requirements to check under 43. If all these criteria are met, then the transaction would come under 43 and legal fiction of the code will come into play. This is the short point of section 43.
Sir, I agree to the point what you are saying. And the facts what I am stating are totally unrelated to this case, what we discussed. But sir, my limited submission over here is, like, as you said, the conditions of preferential transactions. Sir, to a reasonable extent, these conditions are also getting met when we are talking about the margin money which is kept by the bank.
Okay.
And they are trying to adjust that amount because the CRP process is already started.
No, so Abhijit, the basic point which is not meeting here is in the ordinary course of business. The banks are into the business of lending.
Right.
That is not meeting, na?
Okay.
You have to meet all the criteria that the transaction should have happened in the ordinary course of business. Number 1. Number 2, the margin money is lying with the bank. So how would you classify that as a preferential transaction?
Sir, this margin money which is there with the bank is also being shown in the balance sheet of the corporate debtor as a fixed deposit under investment.
Correct. That is a security given by the CD to the bank.
Right. Now, sir, this amount which is in the form of a liquid asset.
Right.
What the
normally
bank
it is a fixed deposit. Normally it is a fixed deposit.
Normally it's a fixed deposit. Yes.
Right.
Now the bank wants to adjust that amount against their outstanding after the start of the CRP process.
No, so what I can tell you here, after the start of the process, no adjustment can happen. But
Right.
I remember there are judgments of the court that this money does not belong to the CD. Even though this money, is shown in the balance sheet of the CD, and this is a margin money given to the bank is not obliged to return that margin money to the RP or to the liquidator because that is not the assets of the CD.
Sir, because when bank is giving any limits, it also includes the collateral which are given to them.
Yeah.
Now, when we talk about these collaterals, which are
I'll tell you, Abhijit. I will make one point here.
Yes, sir.
All what you can do is you can adjust the amount of security lying with the bank while admitting the claim of the creditor. So you can reduce the claim to the extent of that amount, but you can't get that amount, in your possession.
Understood.
That is the only thing you can do.
Right.
That is my understanding.
Oh, very true. It seems logical, more logical.
You can, reduce the claim to the extent of FDR, and you can admit the balance amount as a claim.
Right. Okay, sir. Thank you.
Thank you. Any other participant would like to share their experience in this regard? Because this is a very common transaction in most of the CRP cases of loan given, loan taken. So I'm sure this decision will have a very wide ramification in CRP process, and many more applications are going to be filed based on this judgment of Pooja Bari, which is a very recent judgment of 24th April 2023. So this judgment, I think, would be very relevant for the RPs to quote while, treating transactions as a professional transaction. So let us proceed. I hope, this judgment is now clear to everyone. The next transaction is also very similar in nature. That is why, I have put these two transactions together. So this transaction is, this case is of 29th March 2023. And the nature of case is also very similar. So let us see, in this case, who are the parties involved? Arihant Nenavati is the liquidator of Royal Refinery Private Limited. Now, Vishal Chaudhary and Gaurav Panwar are the suspended directors of Royal Refinery. Okay. And Baiju Trading is basically the person to whom loan was given by Royal Refinery. So he is a beneficiary of the transaction. Let us first see what is the issue involved. So the issue involved is whether the transaction is fraudulent in nature or not. Let me explain you the facts of the case. So Raksha Bullion had filed an application under Section 9 against Royal Refinery, which is the corporate debtor, and Raksha Bullion is the OC. Now the case was admitted on 13th November 2019, and one Mr. Deshpande was appointed as an IRP, later confirmed as an RP. The liquidation order was passed on 16th April 2021, and Mr. Aryant Nanavati was appointed as the liquidator. So Aryant Nanavati is the respondent number 1 here. Now, this Baiju Trading, who's the appellant in this matter, is an NBFC, and he has taken loan from the corporate debtor. So corporate debtor is Royal Refinery. Royal Refinery has given loan to Baiju Trading Company, and similar kind of situation. Again, a loan has been given by the CD to some company, and here what the liquidator is saying, that this transaction is of a fraudulent nature. Why is saying so as compared to a preferential transaction in the other judgment we have just discussed? Because here there is no repayment of loan within the look back period. So he's saying that it is a fraudulent transaction given by the CD to Baiju. Baiju, CD has given loan to Baiju. Now R2, R3, as I told you, are the suspended directors of, so Vishal Chaudhary and Gaurav Panwar are R2 and R3, is respondent 2, respondent 3, suspended directors of Royal Refinery. So what is the business of Royal Refinery? They are into the business of exporting, importing gold after performing manufacturing activities. So this is an important point, that Royal Refinery is not into the business of lending money. They are into the business of importing, exporting gold. Now, the erstwhile RP files an application under Section 66, claiming the loan given by CD to Baiju, what is the company? Baiju Trading. So the loan given by CD to Baiju Trading has been claimed by the erstwhile RP as fraudulent in nature. Because in Section 66, there is no look back period. You can go as number of years back as you feel like. So let us see what are the important facts here. The avoidance application has been filed by the erstwhile RP for 41.03 crores, because this is the amount of loan given by CD to Baiju Trading. Now, the CD has been raided by DRI, the Department of Revenue Intelligence, and the business of the CD has ceased with effect from May 2019. Now, the next point is important, that the loan given by the CD has been written off by the CD in its books of account. So who is the beneficiary here? Beneficiary is Baiju Trading, because the loan was given to Baiju. Now CD has written it off. So Baiju has not to return the amount to the CD back. Now adjudicating authority has passed the orders, upheld the application of the RP, and said that the application is covered under Section 66(1), that is fraudulent trading, and R2 and R3, which are the suspended directors of the corporate debtor, are covered under Section 66(2), which is wrongful trading, and the applicant was directed to refund 41.03 crores into the bank account of the corporate debtor. That is the primary point here, that the loan given by CD to Baiju Trading has been asked by the Honorable NCLT to be returned because it was a fraudulent transaction. Now, how it is a fraudulent transaction, that we'll examine in the next slide. What is the argument made by the appellant? Let us see what are the arguments of the appellant first. Appellant is Baiju Trading, the primary beneficiary of the transaction here. Number one, he says, no forensic audit was conducted by the erstwhile RP. So naturally, no documentary evidence has been given claiming it to be a forensic, a fraudulent transaction. Now, the transaction between the appellant and the CD has duly been reflected in the books of accounts of both the CD and the appellant. And there is no intention to defraud the creditors as claimed by the appellant. The appellant says there is no malified intention of willful misconduct, or there is no collusion between the CD and the appellant. And it has not been established also by the liquidator that there is any collusion between the CD and the appellant. So what the appellant says, there are 3 tests to be passed to make a transaction as a section 66 case. The first point he says is that there should be a clear opinion formed by the liquidator or the RP. Second, he says there should be a suitable determination. So after opinion, it has to be determined. And lastly, he says there has to be concrete finding of the fraud or of this nature, should be a concrete finding. So as per the appellant, these milestones have not been met. Lastly, the appellant says that the borrowing of the appellant was pertaining to the regular business between the appellant and the corporate debtor in good faith. So what the appellant is saying, that Baijo is saying that the borrowing of the appellant was a regular business transaction because it was an NBFC and it was in good faith in the ordinary course of business. Now we have already seen what is ordinary course of business. Now, what are the averments made by the liquidator here? Because the application was filed by the erstwhile RP, however, it was being followed by the liquidator. So liquidator says that CD, that is, the Royal Refinery, is into a bullion business and not in the business of lending money. So this is the important point. The business of the company is a bullion business, export and import of gold, not lending money. And in the bullion business, the general practice is that no credit facility is offered by a bullion trader. Number 2, the transaction is long overdue and the last transaction happened on 16th May 2018. So naturally after 16/18, now nothing has happened. Entire money of the appellant owed by the appellant to the corporate debtor has been written off by a simple journal entry by the CD. Now, before the adjudicating authority, the appellant had termed the transaction as a long-term borrowing. However, it changed its stand before the NCLAT and had said that transaction is of a regular business transaction. So the appellant had changed the nature of transaction before the AA and NCLAT. So what are the observations and decisions of the NCLAT here? As per the normal business of gold business, the transaction of dealing occurs on spot payment basis and there is hardly any scope of lending money. So it is not in the nature of ordinary course of business. Bullion gold business is conducted on thin margins and cash flow of the business is required to be regulated, maintained strictly in order to sustain the growth of the business by way of purchase of gold on a regular basis. Now the appellant made contradictory submissions before the AA and NCLAT, as I had just said, so it does not aspire confidence among the NCLAT. And lastly, it says the very fact that the appellant was an NBFC and the corporate debtor was in the business of bullion and gold, therefore, it cannot be a transaction in the normal course of business. So we have you remember the last judgment we had just discussed, normal course of business. Because the Royal Refinery is not in the business of giving loan, so giving loan cannot be considered as an ordinary course of business. Now, an appellant had made a very interesting argument here that the CD had written off the money, appellant had not written off the money. So what the appellant is saying, the CD has written off the amount, but the appellant has not written off the amount, so he should not be held responsible for it. but the court did not, buy this argument. The respondent number one, that is the liquidator, made serious attempts in soliciting information from the appellants and also wrote emails to R1, to R2, R3, that is respondent number 2 and 3, but they did not get any response from them. It is a settled principle of law. The Honorable NCLAT says that it is a settled principle that the principal beneficiary of fraud will be presumed to be the party who has to return the money of a fraudulent transaction. And Mr. Pratik, can you mute, please? Can you mute? Yeah. Now, the contention of the appellant was that no forensic audit has been done. The Honorable NCLAT held then forensic audit is not mandatory. This is an important point to note. And overall, what the NCLAT held that it was a fraudulent transaction. It upheld the decision of the NCLT and it dismissed the appeal. So this is the judgment we have just discussed. These two judgments are of similar nature. Loan given. One was a preferential transaction, other was a fraudulent transaction, even though both are in the nature of loan. So I keep the floor open. If somebody would like to share his or her experience, we were happy to, share the views. Anybody would like to share his experience on some kind of fraudulent transaction?
Yes, sir. Yes, sir.
Yeah,
Abhijit Jain here.
Yeah, Abhijit.
Actually, I was just going through like in one of the matter when I have identified certain transaction as a 66 transaction. We made an application. Unfortunately, the day we applied for this, out of the 3 directors in the company, 2 were already dead. And
the directors have died?
Yes, they were already died that time, the moment we have filed it.
Okay.
And during the course of this process, the 3rd director has also gone.
The 3rd director is also gone?
Yeah, he's also no more.
Achha, he's also no more, okay.
Yes. So now thing is, the matter is still going on. And we want to take this against the legal heirs of that respondent. Now the thing is, nobody has came forward. We are not aware of who are the legal heirs. Under these circumstances, the court has also abated the application, saying since the respondent is no more, the application is abated. But we know the transactions were not proper; they were fraudulent transactions. So, can we file these kind of transactions which is not yet established?
No,
Since
the point is that
can we go ahead against the legal heirs?
No. The point is, I think that you can go against legal heirs, even though I'm not very sure, but I understand that there should be no bar on it. Number one. Number two, the courts have to actually first decide whether the transaction is a fraudulent transaction or not. Because if you have given conclusive evidence in the application before the court, and the court has upheld it to a fraudulent transaction, then I think
yeah, but that has not happened yet, sir.
No, so naturally that has. So the question of legal heirs will only come when the transactions are upheld to be fraudulent in nature.
So my question is here is, since the respondent is no more, the claims that I have made, there is nobody to counter because he is not surviving. So I don't, are the court in a position to give any direction like this?
Because that should not be that big a challenge, because if suppose you got a forensic audit done or transaction audit done, and there are prima facie evidence to establish that it was a fraudulent transaction, then I don't think that, like in this case, there is no forensic audit.
Okay.
Right.
So here, sir.
Yeah, please.
So audit was done. There's a transition audit was done. They found out these things, but only issue is the company was inoperative. Director is no more.
So directly, the company is inoperative is immaterial. Because what happens, I tell you, in a lot of reports I have seen in the forensic reports, The forensic auditor itself is not sure whether it is a forensic, he has not established anything, and he writes in the report, it may be a fraudulent transaction.
Exactly, sir.
So
Exactly.
then the
There is no
auditor is saying it
concrete
may
thing.
be.
Actually, sir, hello.
Yeah, Mr. Anil Singh.
Hello.
Yeah.
Yeah. May I add something?
Yeah, please.
Actually, in this, sir is asking about how he can claim. He have to be, start his process. If the this beneficiary who is the decision of the directors, if they are getting something from that company, so it can be recovered from the beneficiary because that is the evidence charges. It is established by the law.
Company is already into CIRP. Assets of the company are already in the control of the RP. So it's not a question of recovering it from the company. It has to be recovered from the legal.
No, it is not from the company. It is recovered from the beneficiary. If it is something they are getting something from the DC director, if they are responsible, they are. If you see the CPC cases also, that is there. If there is the beneficiary is getting something from the deceased, and there is some liability, and so if the beneficiary getting something from that, they have to be pay them.
I'm not very clear, what you are trying to say, but what Mr. Abhijit said, my limited point here is that if the report is able to establish conclusively that there is a fraud or there is an undervalued or a preferential transaction, and it is established beyond doubt, and the courts are convinced that it is a transaction of coup in nature, then the next step comes how the money will be recovered. The first step is that it has to be established it is a profit transaction.
Sir, here one interesting point was there.
Yeah.
This company, the company which I am talking about, this was under BIFR.
Okay.
And the CD themselves has filed the application under Section 10.
Okay.
So there is one point where it says the creator feels like the CD feels that they under any circumstance they can revive the company, and still they are running the business. So it is a fraudulent thing.
No. Can you explain again? I'm not very clear what you said.
In one of the
it was a Section 10 application, right?
Section 10 application.
Right.
So the CD was aware that they cannot survive with this company.
They cannot survive with this company
because the company was under BIFR. It was already NPA company.
Okay, so they were anyways not eligible to give a plan.
Yes. Then they filed under 10, but when the BIFR was repealed and on the introduction of this IBC,
right,
they moved to IBC.
Right.
Application was filed in 2017.
Right.
Audit was passed in the year 2019 December.
That's fine, but even though it is a Section 10 application, then how do you establish that it is a fraudulent transaction?
Because there is one of the clause when it says if the promoter knows under any circumstances they cannot keep the company surviving.
Okay.
Because it was under BIFR, they themselves are filing for CIRP. They know the company is going to be
I think
company.
No, you are not going in the right track. I think you are referring to Section 66 of Clause 2, wrongful trading. So the point is, if you read Section 66 of Clause 2, the director must have, basically it says that the director must have done something which is not done by a person with common understanding and knowledge, which should not have been done by a person of reasonable understanding, because the company was in any ways going to go into insolvency. So I don't think BIFR case of Section 10 has any relevance to this fraudulent application. But the facts of the case is not known, so it is difficult to discuss. Maybe we can discuss offline separately on what is the issue involved.
You see, here there is subsequent to you rightly referred, sir. It talks that before the insolvency commencement date, the director or partner knew or ought to have known that there are no reasonable prospect of avoiding the commencement of CIRP.
Correct.
And when they are themselves moving to CIRP, still they are transacting with a related party and continue to incur further losses to the company.
So you'll have to see now what kind of transaction. These matters are a little complex. You'll have to go into the complete facts of the case. Otherwise, if you don't have the complete facts, or if you're not drafted your application well, if there is even an iota of doubt, then NCLT will dismiss the application.
Reason being, sir?
Because you have not established beyond doubt that it is fraudulent or preferential in nature.
So, no,
Because
as
you are saying that the report of the forensic audit itself says that it may be a fraudulent in nature.
Concrete report they have not given also.
So that will not, then it will not stand the test of law. I think let us proceed, because we have limited time left. So we can discuss offline, Abhijit.
Sure, sir. Sure, sir.
Yeah. Let us see the next judgment. Here, the judgment is the limited point before the NCLAT was an FC who has not attended the COC meetings, can he challenge the CIRP process? He is not attending the COC meeting. Here, Consolidated Finvest is a financial creditor. Subhash Kumar Kundra is the RP for CLC Industries. So basically what happened, the financial creditor is challenging the approval of the plan and is saying that the whole process has not been conducted properly when he has not been attending the COC meetings. This is the limited point before the court. So let us very quickly see what are the facts of the case. As I told you, Consolidated Finvest is a financial creditor and the name of the CD is CLC Industries. RP approved a resolution plan approved by the COC was challenged by the appellant. However, the such challenge was dismissed by the NCLT by its order dated 25th January 2023. The appellant challenged the entire process as not legally done, and he requested the court to issue the process of EOI afresh. Now the CIRP is initiated in January 2020. Form G is issued in March 2020. The Form G is extended 6 times. Please note, the RP has extended Form G 6 times. And finally, when the resolution plan is approved by the COC on 5th April 2021, RP files the application for approval on 20th April 2021. The Consolidated Finvest challenged the order of approval of COC in the NCLT in September 2021. So he is challenging the approval of the plan by the COC, saying that the process has not been properly conducted. So out of the 16 COC meetings, only in one COC meeting, the appellant has attended. So out of 15 he has not attended, and one meeting he has attended, and he has neither voted nor raised any objection regarding the process. So the NCLT imposed a cost of 10 lakh rupees on the applicant and dismissed the application. Now he has gone into NCLAT, challenging the decision of the NCLT of imposing cost and not giving relief to the applicant. So what the NCLAT is saying, the financial creditor has been given rights under IBC to take steps for resolution of the CD, and financial creditors do not intend, and financial creditors who does not attend the proceedings cannot be heard in saying that process has wrongly been conducted. So this is an important observation for RPs, that if a COC member is not attending the meetings, he cannot challenge the process. This can be helpful to us in certain circumstances. Second is, the appellant has made several prayers in the application, and one of the prayer was to change the RP. Appellant has permitted for filing fresh application. However, appellant not. The appellant has made several prayers in the application, and one of the prayer is that appellant may be permitted to file fresh plan. However, appellant has not filed any plan in response to Form G. So the cost imposed by NCLAT was upheld, and the application was dismissed by the NCLAT. So the judgment of NCLAT was held to be correct, and no relief was granted to the applicant. So there is a limited point here. Let us not, waste our time in this judgment. It is a simple case. So I think, let us discuss this judgment. This is important judgment. So this is, Jagdish Kumar Parulkar. This is a liquidator of Kapil Steel. Here the facts of the case is a little complex. So we would spend about 15-20 minutes in understanding this case. There are 6 respondents here. So let us see what is the issue involved here. Whether the transaction is a PUFE transaction or not. Again, similar kind of issues involved. And the judgment is of 21st March 2023. It is a recent judgment. So let us understand the facts of the case, because the facts are a little complex here. So Patni Carbides, in short PCPL, acquired a piece of land of 10,000 square meter on lease of 99 years from Madhya Pradesh Industrial Development Corporation, that is MPIDCL. MPIDCL is respondent number 6 in this case. Now, to obtain the said land, PCPL, that is Patni Carbides, took a loan from MPFC, that is Madhya Pradesh Financial Corporation. So Patni Carbide defaulted, and Madhya Pradesh Financial Corporation auctioned the land, and Kapil Steel, which is the CD or the corporate debtor in this case, acquired the land from MPFC for 60 lakhs. So this is how the land came into the possession of Kapil Steel, and the sale deed between the MPFC and Kapil Steel was executed on 23rd February 2020. These dates are important. 23rd February 2020, the land was registered by MPFC in name of the CD, which is Kapil Steels. Now, the next point is very, very important. CD did not get the lease deed executed in its favor from MPIDCL, right? So the land is on lease. One of the requirements that we'll see in the next slide, one of the requirement of the deed was that the owner of the land has to get the deed registered in its favor with MPIDCL. Now what happened? Kapil Steel went into insolvency. On 28th July 2020, the application was admitted, and then it got into liquidation on 1st October 2021. Now let us see the further facts of the case. Now the corporate debtor, that is Kapil Steel, sold the land with the tin shed. There was a small tin shed constructed on the land. He sold the land on 1st February 2020. Please note, CIRP date is 28th July 2020. So prior to the CIRP date, the land is sold by the CD to a company called PTL, Powerage Towers Limited, and PTL happens to be a related party of the CD. The total value of sale is 7,81,000. So if you remember, the land was purchased for 60 lakhs by Kapil Steel. The said land has been sold for 7.81 lakhs to a related party. Now, what PTL did, it in turn sold the land with the tin shed to another company called Indore Steel and Alloys Private Limited, ISAPL, on 13th November 2020. That is after the CIRP date. So the sale of land between the CD and PTL happens prior to CIRP, and the registration of sale between PTL and Indore Steel happens after the CIRP. Now the next point is very important. MPIDCL, after receiving, so if you go to the previous slide, I had already stated, corporate debtor did not get the lease deed executed in its favor from MPIDCL, right? And Indore Steel has got the land transferred and registered in its favor with MPIDCL. So MPIDCL, after receiving the transfer charges and other outstanding dues from Indore Steel, also transferred the leasehold rights in the subject land to Indore Steel. Now what happened? The liquidation process started. So the Indore Steel, which is respondent number 1, filed an application in the NCLT stating that their possession should not be disturbed during the liquidation process. Now the liquidator filed an application before the NCLT says that this is a transaction within PUFE and the transaction of sale should be reversed, right? The NCLT passed an order on 5th May 2022 stating that basically disposed of both the application. It said that Indore Steel would retain the ownership of the land, and it said that liquidator will not disturb the ownership and possession or interfere with the titles of the Indore Steel. That is what is the order of NCLT. So agreed by this order, the liquidator filed this application before the NCLAT. So let us see what are the important provisions of the sale deed. These are very important. This has to be seen in the facts of the case. There are certain important points in the sale deed between MPFC and Kapil Steel, and there is an MP rules which is called as the Madhya Pradesh State Industrial Land and Building Management Rules. There are certain important provisions which has to be seen in the facts of the case. So as per clause 6 of the sale deed, it says that the assignment of lease right was conditional and it was obligatory on the CD to get the approval of MPIDCL within 6 months of the transfer. So the sale deed had very categorically stated that the buyer of the land must get the land registered in its favor with MPIDCL, because the land is actually government land owned by MPIDCL. It was given on lease, so it must be registered with MPIDCL. Now, Rule 9B of the MP rule says that the transfer of leasehold rights would be effective only when MPIDCL executes the lease deed in favor of the new allottee. And Rule 19C says that if the said transfer is not taking place in 6 months' time, then there is an automatic cancellation of the lease. Now, the last point important here is Section 107 of the Transfer of Property Act, which says that any immovable property which has rentals exceeding 1 year needs to be registered. So registration was a compulsory as per Section 107 of the Transfer of Property Act. Yeah, Chirag, kindly mute, please. Okay, so what is the argument of the liquidator stating that, this is a buffet transaction? So what are the arguments that the liquidator is giving? The first argument he's saying is the land was purchased for 60 lakhs in 2010. It has been sold to a related party only for 7.81 lakhs. So it was an undervalued transaction. Second point the liquidator says is that the land has been sold to Indore Steel for 40 lakhs. So PTL has sold the land in turn to Indore Steel for 40 lakhs. However, the CD has sold the land only for 7.81 lakhs to PTL. Now it says the amendment to the lease deed records the chain of documents regarding the transfer rights from PCPL, that is Patni Carbide, to CD, to Powerage Towers, to Indore Steel. That is the chain. Now, the NCLAT held that the chain was broken because the lease was never executed by the CD with MPIDCL. So the CD had only acquired the ownership rights, but not the leasehold rights. Now, what are the important observations and issues before the NCLAT? The first important issue is whether the transfer of land by MPIDCL to Indore Steel has been executed in accordance with law, and if so, whether there is any merit in the claim of the appellant. Appellant is the liquidator, that the transaction was not done in good faith and was fraudulent and preferential in nature. The second point is the CD, in spite of being aware that it was under an obligation to get the lease deed executed, did not do so with MPIDCL, and for the next 10 years, the land remained unregistered with MPIDCL, and it was finally sold to PTL on 2020. Now, clause 6, as we had just read, of the sale deed says it was obligatory on part of the CD to get the land registered with MPIDCL. Now, MPIDCL is a wholly owned subsidiary of the government of Madhya Pradesh, and it is bound by the rules of the government. So there is no error in the findings of the adjudicating authority that MPIDCL has fully authorized, it was fully authorized, being owner of the subject land, to execute the sale deed in favor of R1. Corporate debtor had only deposited 10.59 lakhs with MPIDCL. It had not paid the balance amount of 20.49 lakhs to transfer the land in its favor. So Indore Steel had purchased the land on 13th November 2020. It had paid a consideration of 11.72 lakhs to PTL, and it had also paid 38.09 lakhs to MPIDCL for getting the land registered in its favor. So effectively, it is paying almost 50 lakh rupees here. The second point here is that Indore Steel had paid the consideration directly to MPIDCL, and it has not entered into any, and it has further entered into a lease deed with MPIDCL. Now, the transaction between Indore Steel and PTL related to the purchase of land, and the transaction between Indore Steel and MPIDCL was for leasehold rights. So there are two separate transactions here. One is for sale of land and one is for acquisition of the lease rights. CD never acquired the lease rights, and MPIDCL has directly transferred the lease rights in favor of Indore Steel. So finally, what the court has held, this is the final observation. It says the liquidator, being an officer of the court, has to display high level of professional maturity, fairness and restraint in the conduct of liquidation process, and is not expected to be overzealous or overreach in detecting traces of preferential, fraudulent, undervalued transactions in respect of interest in the property owned by a person who has acquired such interest from a public authority in good faith and for value. This is the observation of NCLAT. Mere possibility of a potential collusion without material on record is not sufficient to persuade this bench to record any findings on operational or fraudulent transaction. And hence, the appeal of the liquidator was dismissed, and Indore Steel was the rightful owner of the land and possession of the said land. That is, in a nutshell, the judgment. So I have one last judgment, but I think, time is already, we are already 4:30. So, if you want, I can cover this judgment or I can skip this judgment, as the Institute of Company Secretaries advise. We have one more judgment left here. If you can wait for 5-10 minutes, we can quickly close it.
So you can continue for 5-10 minutes if that's okay with everyone.
Okay.
Yes, sir. Please proceed.
Okay, fine. So this is a judgment where you have, one gentleman called Mr. Karthikeyan, who is a proprietor of MSK Lottery, lorry booking. He is a member of the Stakeholders Consultation Committee. R. Venkata Krishnan is the liquidator of John Freight Systems, that is the CD. And GC Logistics is the successful bidder of the company undergoing concern under liquidation process. So respondent number 1 is the liquidator. Respondent number 2 is the buyer of the company, John Freight, as a going concern. And Mr. Karthikeyan, who is the appellant here, is a member of the Stakeholders Committee. This judgment is again of a recent judgment, 17th March 2023. So let us hear what has happened here. That the appeal has been filed against order dated 19th January 2023. And CD John Freight was sold as a going concern to GC Logistics as a going concern. So appellant, as Mr. Karthikeyan, is the member of the Stakeholders Committee. So the main contention here is Mr. Karthikeyan is saying that the principle of value maximization has not been followed. So his payout under section 53 is getting impacted. So the process has not been held properly. The process has been run erroneously. Basically, what is happening here, Mr. Karthikeyan is acting as a front for the promoters. Promoter had given a plan under section 230 of the Companies Act, and they had offered 170 crores. The promoter, the COC or the SEC was not inclined to accept the proposal of the promoter, and they sold the company as a going concern to GC Logistics for only 44 crores, whereas the promoters were offering 170 crores. So the appellant is saying here that the process is erroneous, and the payout is not meeting the value maximization principle. So the appellant here made various allegations against the liquidator. Even he filed an application for replacement of liquidator, but all his applications were dismissed by the court. So what are the arguments made by the liquidator here? The liquidator says that in the 9th meeting, when the proposal for sale as a going concern was received and put to vote, appellant that is Mr. Karthikeyan, was part of the said stakeholders committee, had voted against all the proposals. Now, what is the reason he is giving up voting against? He is saying that he is rejecting the proposals because he wants the promoter to take over the company. Because the promoter is offering 170 crores, he is insisting that promoter should take over the company. So the liquidator is alleging that Mr. Karthikeyan is acting as a front for the promoters. Now, the transaction has fully been completed. The sale agreement has been executed. The amount has been received. Amount has been distributed as per section 53. The successful bidder has also retained all the employees of the company, John Freight. Now even the liquidator said that he had carried on a Swiss challenge to sell the company, because initially there were two proposals of GCA Logistics and Galaxy Freight, but none of the proposal received 66% vote. So he filed an application in the NCLT stating that he would go for a Swiss challenge and he would keep the base price as the offer given by GC Logistics, and he will go for a Swiss challenge. So NCLT allowed this Swiss challenge, and finally GC Logistics was considered as the successful bidder for 44.64 crores. So Mr. Karthikeyan had also filed an application against challenging the Swiss challenge, which was also dismissed by the Honorable NCLT. So what are the observations of Honorable NCLT here? And NCLAT says that before AA, the appellant did not point out any irregularities. So a very similar kind of case where he has not pointed out any irregularities during the liquidation process, but subsequently he is pointing fingers towards the liquidator, saying that the process has not been properly held. So he would be barred from raising these objections on a subsequent date. The appellant has no vested interest in the CD. This is important. And the application has not been filed, and the application has been filed only to disrupt the liquidation process of the corporate debtor. So the appeal was dismissed, and the judgment of NCLT was upheld by the Honorable NCLAT. So this brings me to the end of my session. Yeah, thank you very much. So in case there is any question and answer, we can maybe address those question and answers. Otherwise, we can close it. I'm sorry, I have exceeded 6 minutes.
Sir, thank you very much, sir, for a wonderful session.
I would request all the participants to please put forward their questions if they have any.
What is the name of the last case law which we discussed? Sir, the name of the last case law, please.
I'll just repeat, sir. I'll just take you. Karthikeyan, Mr. Karthikeyan, proprietor, MSK, Lorry Booking Office. In any ways, I will share this presentation.